Hi everybody, April Jones here. I have been an attorney now over 33 years, and Jones Law Firm has been serving clients in Colorado, and we are in our 24th year. This webinar series, I'm so excited to bring it to you. It's helping us with our mission of education, enlightening our clients, and really helping you try to get to the next best place in your life. So we've got a lot of good information for you. We've got experts, we've got our team, we've got panel discussions, and so much more. So let's go see what this webinar is about, and I will see you on the other side.
Good afternoon, everyone. Welcome to our webinar, Navigating Family Law Cases Involving Mental Health and Addiction. I'm Haley Hollins, and I will be your host today. Family law cases are challenging enough, but when mental health or addiction issues are involved, the stakes are even higher, especially when it comes to protecting your children. Today, our Jones Law Firm attorneys will share insights on how courts handle these cases and to provide some actionable steps to help you safeguard your family's future. As we go along through the session, please do feel free to submit your questions in the chat function of this webinar, and we will address as many as we can during our Q&A portion. Thank you for joining us. Let's get started by introducing our panelists. David, we'll start with you.
Yeah, good afternoon. Thanks for joining us. I'm David Collins, managing attorney at the law firm. I do all aspects of family law, including divorce, allocation of parental responsibilities, paternity, guardianship, step-parent adoption.
Wonderful. Thank you. And Grant, would you introduce yourself?
Good afternoon. My name is Grant Bursick. I'm one of our senior associates here at Jones Family Law, and like David, I handle all aspects of family law cases.
Great. Thanks for being here. And Will, would you please introduce yourself today?
Of course. Good afternoon. My name is Will Garvey. I'm also a family law attorney at Jones Law Firm, handling all aspects of the cases as well, family law cases as well.
Wonderful. And my name is Haley Hollins. I am a senior associate attorney at Jones Law Firm. I've been practicing family law in Texas since 2016 and Colorado since just about last year. And so, Will, we'll go ahead and stay with you since you were the last one up. I'd like to start today talking about, for our participants, what the common mental health issues and addiction issues that we see. What are those? How do they impact the decisions and arrangements?
Sure. Thank you, Haley. So some of the common issues we see are, alcohol, or at least for addiction, or alcohol and drug addictions. Sometimes more rarely we see addictions to electronics, it could be pornography, something else like that, that really could just have an impact on how a parent's fitness to raise their children. Alcohol and drugs are a bit easier to see. It's pretty obvious how that will affect the child's life. If a child has to get to school, but the parent has been drinking in the morning because of their addiction, there are safety concerns with getting the children to school. Likewise with drugs, anytime that the parents really have the kids while they are impaired is a very large risk for something to go wrong with those children, and for the safety concerns in relation to that. So this is something courts look at very closely when trying to determine parenting time with the children, decision making. As we know, alcohol can impair people's ability to make decisions. So can drugs. So it can really impact a court's allocation of parenting time, decision making, anything like that. As well with mental health concerns that could also have a severe impact on children's safety. It's something unfortunate we see quite often in these cases. You see, manifesting with suicidal tendencies. Of course, there's an enormous safety risk with children in those instances. They could, God forbid, a child has to discover their parent after they have made, hurt themselves, killed themselves, anything of that sort. So of course, those are enormous concerns with these cases, and courts really look at these closely and will often deal with them before deciding any sort of parenting schedule, often dealt with like early on in the case.
And that makes sense. And Grant, along those lines, when, in your opinion or your experience, does it become appropriate for the court to kind of start addressing mental health issues or substance abuse issues? Like when Will was giving us some examples of things that are legal, like pornography or marijuana or alcohol, or mental health. When does it become something that the courts care to intercede with?
So I think with respect to substances, it's a little bit of a brighter line than when you're dealing with mental health challenges. There's nothing wrong with having a glass of wine after work, even when you're parenting. but the courts are pretty consistent in that they believe that it's in the children's best interest that children have effectively sober caregivers and providers. Um, when an individual starts to get into the realm of having a substance use disorder, that's when courts will sort of take action. The challenge is how can that be established? Well, one, if there are concerns about substance use, the court can order a substance use evaluation. They can also order a party to obtain drug testing. Typically, we would ask for hair or nail, as it can kind of show longer term drug use. If there are presence of, explicitly illicit drugs, cocaine, methamphetamines, that's going to raise red flags with the court right away. And so those are sort of and a CFI or a PRE can also sort of opine as to whether or not someone's substance use has sort of crossed over into problematic or use disorder, as opposed to just, having a beer or two after work. With respect to mental health, that is a little bit more tricky. I think first, the courts understand that when you're going through a divorce or an allocation of parental responsibilities case, no one's at their best mental health, right? These are inherently stressful and difficult circumstances. It's also not uncommon for people to suffer from anxiety or depression. Again, just because someone has a mental health disorder doesn't mean it's going to negatively impact their parenting. And so I think for the courts, that's what they're really looking for is, does this mental health issue negatively impact the parent's ability to parent the child safely? Obviously, if we're dealing with schizophrenia or bipolar disorder, some of the more severe mental health disorders, even those in and of themselves aren't necessarily going to impact your parenting time in so much as you are managing your illness appropriately. I know for especially bipolar 1 disorder, as long as you are consistently taking your medications and managing your illness appropriately, you're going to be fine. But if there suddenly becomes a problem and someone stops taking their medications or they have a severe flare-up, typically we're going to see the courts get involved very quickly because it ultimately does become a big safety issue for the children.
Excellent. Thank you for that, Grant. And so, David, how would you advise a client on what steps they should take to prepare their case when they believe that mental health or addiction is going to be a factor, whether it's a concern that it's going to be used against them or even that it's with their co-parent?
Sure. Either way, the party who's being accused of having a substance abuse disorder or having a mental health issue likely will have to establish to the court that those issues, like Grant said, don't affect their ability to parent. If you're the parent with the alleged issue of substance abuse evaluation, one way to quickly nip that in the bud is to have a comprehensive substance abuse evaluation done by a professional who can then prepare a report for the court about whether the person does or doesn't have a substance abuse issue. And if they do, propose a treatment plan to get them on the right path. The same can be said for the opposing party. If you're the mom in a case and dad has a drinking problem or a cocaine problem, you can file a motion with the court asking the court to order that individual to undergo a comprehensive substance abuse evaluation. And those are really useful. Those usually include, if they're valid evaluations, pre and post testing of the individual, either through urine, blood, or hair, to get a baseline of what's in their system when they start the evaluation and what's in their system at the end. So the evaluator can at least opine to the court whether the quantity of the drug or alcohol in their system has gone down during the course of the evaluation. The same for mental health. If a party has concern about the mental health of the other party and they have sufficient information for a court to grant their motion, they can ask the court to require the party to undergo a psychological evaluation as part of a parental responsibilities evaluation. Generally, if those are ordered in a case, both parties undergo the evaluation. So when my clients are ready and gung-ho to try to force the other side to undergo some kind of mental health evaluation, my first caution is, so will you. If the court appoints a PRE, they're going to take a hard look at both parties' mental health and administer the same exact tests to both parties. So there's a piece of caution there. The other piece of caution with mental health is that a diagnosis doesn't make you an unfit parent. I have heard judges say time and again, I understand that mom has depression, but mom sees her therapist and has a prescription and takes it every day. And I don't have concerns about mom's mental health because she's appropriately managing it. We hear constantly from our clients that the other side has whatever mental health condition you generally would hear during a regular NFL football game commercial series, right? My ex is bipolar. My ex is schizophrenic, and so on. And it doesn't mean that the clients are wrong, but it's not as easy to diagnose somebody as the commercials we see on television might make us believe. And it can be actually really difficult to prove someone is bipolar or schizophrenic to the degree that it would affect their parenting.
No, thank you.
And Haley, do you mind if I add something to that?
Yeah.
I think, sort of following what David was saying, if you have concerns about your spouse's or partner's mental health, be very careful about diagnosing them either to the court or to the PRE or CFI. I have seen that get used against parents when they do that. I think it's okay to say that you have concerns about their mental health and maybe you have concerns about a specific disorder, but you shouldn't ever diagnose someone because that is for a medical professional to do. I've also seen where parents discover in cases that they have a mental health disorder that they didn't know about, prior to the case and the testing and the stress of the case. It becomes really important then that you are in treatment following your therapist or your medical provider's recommendations and treatment protocols. And then ultimately that information can be provided to the court at a hearing, and that usually helps overcome the concerns. Because no one expects any parent to be perfect, but what sort of the expectation is that you do get the treatment you need for the benefit of your child.
No, and that makes a lot of sense. And to either of you, when we were just talking a little bit about the remedies that the court can do when these issues are raised, have either of you ever had an experience where the court mandated therapy or actual treatment? Or how do you see that the court actually wants to solve these issues once they've been acknowledged or found?
I absolutely have. I worked with a client. He was a medical doctor and he suffered from bipolar 1 disorder. So did his twin brother, which was sort of interesting when looking at prevalence of, disorders like that within identical twins. And during the case, he stopped taking his medication and ended up hospitalized. And the court issued very clear orders regarding his ability to exercise parenting time and his needing to take his medications, continue to attend therapy to provide proof to the other side that he was compliant with his medications. And if he didn't follow the treatment protocols in the parenting plan or the orders already contain information as this is how parenting time is then limited. It very much happens when there is concerns like that.
No, that makes sense.
And I'll add to that, Haley, if I can, that for substance abuse, if the court believes someone has an abuse problem, I'll give you two examples. For alcohol, the court can and often does order a party to stay sober and orders them to use something called a SoberLink device, which you keep at home. It looks like a police officer's radar gun, but you actually blow into it. It takes your picture when you do, and it immediately tests your saliva for alcohol. Those results are then immediately sent both to the person who took the test and to the other parent. Generally, if you're on SoberLink, the court requires you to do it when your parenting time begins, breakfast, lunch, and dinner during your parenting time, and immediately before ending parenting time. And that either helps keep a parent sober or reveals immediately that a party is not sober. A skip test is a positive test, so you can't skip a test on a SoberLink. For cocaine, and I'm just saying cocaine because that seems to permeate the cases at our law firm more than we would expect, where parties are recreationally using cocaine on a regular basis. The court can order the party to undergo a hair follicle or a nail test, which will look back somewhere between 3 and 6 months at their usage, but also create a quantity in that hair or fingernail sample. And then the court would expect, as they keep taking these tests, say every 3 months, that what's in their system goes down until it's at 0. And I see that ordered on a regular basis where the issue is cocaine or fentanyl or crack or meth. And the right test there is hair follicle and nail, because the nails and the hair hold both the drug used and the quantity that was in your system for a long time.
No, thank you. And that makes a lot of sense. And so, Will, coming back over to you, we talked a little bit earlier, CFIs and PREs were mentioned. Can you go through what those acronyms stand for and what their role could be in being helpful in a case when addiction or mental health are at issue?
Of course. Yeah, so just to start off, the acronyms, the CFI is a child and family investigator. That's kind of the intro level of this process of having a neutral third party really come in and assess not only the children, but the parents as well. These are people with backgrounds in mental health, normally therapy or psychology. Something along those lines, normally more geared towards children in those cases, because that's really what they're assessing. And they can really assess what kind of impact the parents, alleged mental health issues or alleged substance abuse have on the children and their ability to raise those children. They're going to come down at the end of this. They're going to meet with both parties. They're going to meet with the children. They're going to look at the home environments. And at the end of their time investigating the cases, they're going to issue a report that has recommendations on parenting time. So they will, they'll kind of have an in-depth look at what the home situation is. If there are effects from one parent ingesting alcohol or any other substances, they'll write a recommendation regarding that. But it's more of the entry level position for something like that. The next step up would be a PRE. And you'll have to forgive me, I sometimes forget this acronym. It's Parental Responsibility Expert or Evaluation. Evaluation.
Yeah.
Mix those two up there. And that's kind of the next level. Whereas the CFI has the background in therapy or psychology, something of that line. PREs, you typically see more experience in those fields. It's not uncommon to see an actual psychiatrist or a psychologist who is involved in this, someone with more experience typically than a PR or a CFI, and they're going to do a much more in-depth investigation into what's going on with the family. And David and Grant, I believe, mentioned this earlier. This is where you're going to see a full, almost, if not a full, almost a full psychiatric evaluation of both parents in this instance. They're going to get in to the mental health of both of those parents. They're going to look at the substance use of both of those parents. When you really have concerns for mental health with one of the parties in the case, a PRE is going to be the better option because they are much more well equipped to deal with these situations, and their report is going to be much more in depth. So that's the real main difference between those two. It's also the timing it takes. A CFI is, typically we see 90 to 100 days for a turnaround, where a PRE can potentially have something done in 120 days. But because it's much more in depth, they typically take a little longer to have those reports out and given to the court.
No, and that makes sense. And we actually have a viewer question that I wanted to follow up with you on, Will, and also to get Grant and David's input on this, because I think this is a very serious thing to address, which is one of our viewers asked, if you can't afford a CFI or PRE, what are your options? And when it comes to these serious, significant concerns and then the ability to afford a report, what generally would you tell a client who has those kinds of concerns moving forward? Will, I'll start with you, and David and Grant, if you have anything to chime in for that.
Sure. For background, CFIs are typically capped at around $3,200 for their evaluation. You can always go above that. They typically have an hourly rate as well. So all their work is kind of going to be limited. If it's $3,200, that's roughly 16 hours of work that the CFI is going to put to the case. A PRE, they're a little more expensive on the hourly rate, and there's not really a cap for what the report's going to entail and their investigation is going to entail. You can always come to an agreement on that, but you're looking for a PRE, it's $7,000 to $10,000 range is kind of what is expected for that. And to get back to the question, if you can't afford a CFI or PRE, you can always file something with the court to ask for the fees to be reduced or for the state to cover a portion of those fees. Especially with the CFI. A PRE is a little bit more difficult. Of course, everyone is going to require different levels of help. And if there is a case with large, mental health concerns, large substance abuse concerns, a PRE is going to be more appropriate than a CFI, and the court will step in and give financial assistance or potentially even waive the costs associated with this. You can also see one party being, if they're the breadwinner in the family, and because of if they're going through a divorce with this, or it's just an allocation of parental rights, they'll award the party with the more money. They'll not, I shouldn't say award, but they'll order the party with the more money to pay for more of the cost, typically in those situations, or the entire cost.
No, that makes a lot of sense. Grant or David, any other input for anyone seeking for answers on finances for these issues?
Yeah, I think if you are unable to afford a CFI or a PRE, but there's still significant concerns, I think what you do is you file a motion with the court asking the court to order, say, a substance use evaluation, or order drug testing, or order psychological testing. It should be narrow. The request should be narrowly focused to the specific issue that you have issues with. But I think that is how you can try and best address it. Also, if there are already mental health providers involved with the family, you can always bring them in as witnesses, so long as the appropriate waivers are obtained. The one thing I would add from what Will said is, in my experience, PREs, at least the ones that do their job well, their evaluations can cost anywhere between $50,000 to $30,000. I've yet to see a really comprehensive PRE evaluation come in under $10,000. So it's not realistic for most families because of how expensive their work is.
And if I could just add to that, so the court can order that the state pay a party's portion of a CFI report. To qualify for that, you basically have to fill out the same form you would fill out to qualify for a public defender in a criminal case, which means you have to be basically below the poverty line. And we do occasionally have clients that qualify for state pay for the CFI because they are personally below the poverty line. There is no similar ability of the court to contribute to the cost of a PRE. So the parties are entirely responsible for the cost of a PRE. And I agree with Grant, the range can be $7,000 to $30,000. I haven't seen one come in for under 10 either. But you can ask the court to allocate all the cost to the other party. If you're in a divorce, you can ask, and the other party is controlling all the marital funds, you can ask the court to order that you get access to the marital funds so you can pay your portion of a CFI or a PRE.
Right. No, and thank you for that information. I think that makes a lot of sense. But we have a couple of more viewer questions. I do, just before we get to those, wanted to kind of just address a question that we also received, which is, can mental health or addiction concerns result in losing custody? And I can field that one, and others can weigh in. The answer is yes, it can, certainly. Is that if it begins to affect your children, if your mental health or your active addiction are hindering your, in any way, ability to make decisions and to provide right for your children, that it is something that the court can modify, and frankly should and will modify if your children's best interests are not being served by a parent who is unable to parent. I simply just wanted to address that one, since that was one question that we received. But then also I wanted to give to, I don't remember, I think David, are you next?
Sure.
Okay. What should you do if the other parent relapses once you've already got orders in place? The case is resolved and then the other parent gets back into their active addiction, whatever that may be.
Sure. So first, you could try to negotiate with the other parent if they're willing to go back into treatment and monitored sobriety. If not, and you think that the parent's addiction, drug use, or alcohol use is putting the children at danger, you can file a verified emergency motion to restrict that parent's parenting time because they're putting the child at risk, and ask the court to order that person to undergo testing and treatment if the testing proves that they are in fact using alcohol or drugs during their parenting time. Unfortunately, we have many clients and opposing parties, particularly with alcohol, who relapse constantly and on a regular basis, who have been through therapy after therapy and can't succeed. Alcohol, in my opinion, is by far the worst addiction in family law, partially because there are liquor stores in every corner. There's liquor at the grocery store. There's liquor in every restaurant. There's liquor at every sports venue and every music venue. You can go to any restaurant in town and see parents drinking at the table with their children. It's legal. So alcohol is just difficult to get away from for those who are addicted to it. And it's a particularly brutal physical addiction that's pretty punishing to the party who is an alcoholic and tries to quit.
Mm. No, and you're exactly right. And I think that it's important to notate that sometimes relapse can be a part of the not straight line of recovery. And so figuring out how that setback, if it was temporary, if it is something continuing, how it was it during parenting time, every case being so unique and different is why it's so appropriate to speak with an attorney about any concerns that you've got for this. And so for our last few minutes, we've got just a couple more Q&A questions from our viewers. Grant, I will ask you this next one. What have you seen happen in a more complicated case if one party has a mental health issue, but the other has a violent felony conviction? And so I think what this person is looking to see is how would the courts balance that out if there are issues raised with both parents into that regard?
Ooh, that is super challenging. I think, the court is going to have to sort of take a detailed analysis of both situations, right? With the violent felony, was it against the other parent? Was it against a family member? How long ago did it take place? Is the individual incarcerated? Are they on probation or parole, right? All of those are going to impact how the court looks at it. With respect to the mental health issue, how severe is it? Is the parent properly managing it, right? Are there other family in the area that can step in and help if need be? Though a situation like that is why ultimately you hire a very good and very well experienced family law attorney who can help sort of not only navigate you through it, but also help present options to address these situations, and especially if there's going to be ongoing concerns. And they can also give you insight as to the judge that you're going to be in front of and how they're going to view it, because every judge looks at these things differently, and they ultimately have the authority. And just to follow up about the question that was asked to David, a good parenting plan where especially substance use disorder is identified, is going to have language that specifies exactly what happens to parenting time when there is a relapse. And while I agree with David that alcohol is one of the most challenging substance use disorders, in respect to parenting cases, it's also the one that we can really easily test for, right? We don't have SoberLink for cocaine or marijuana. And so we're able to get real-time results as to whether or not someone is drinking, which can be really helpful in determining what are appropriate steps.
That makes a lot of sense. Thank you. And Will, I've got another attendee question for you. What would your suggestions be to a client when the court has failed to take seriously some raised issues of domestic violence, abuse, or coercive control, despite having raised the issue with the court previously on a number of occasions? What are some ways you think could get that back in front of the court, or ways to address those concerns?
Sure. Yeah, I mean, this is a great question. This is something we unfortunately see all too often in a lot of cases. I don't want to make excuses for the courts, but they're backed up. They want you to deal with these problems. They want to see evidence of these things in front of them before they can take action. I've got a number of clients who are in situations like this, and my advice to them as well is document as much as you can in relation to all of this. Go and try to get third parties, affidavits, anything to talk about this. I often see stuff in relation to children coming up. A child telling something to their parent while they're involved in a divorce that goes kind of against what the other parent wants, goes against their parenting time, is always going to be something suspect to a court. Is that parent just making something up to get more parenting time? So, if you can get those kids into therapy, even speaking just to a school counselor or something, who they can relay that information to, and then have that come from a neutral third party. This is someone doesn't have, a horse in this race. This is someone who is really there looking out for the best interests of those children through their job, through their profession, anything like that. Getting a statement from them, and then, getting that to the court really lets the court know there is an issue here. This is something we need to have dealt with. That's often going to be the first step. You can sometimes file motions to restrict or motions to modify parenting time if this is something post-decree. You can get something filed with maybe not all of the evidence at the moment, but at least getting the court's attention to something like this, that they need to start investigating this. Again, go back to the CFI or the PRE. those are people who are going to be able to help with this. But as David mentioned before, cost concerns are real when it comes to these issues. So yeah, the school counselor, you're not going to be paying anything extra out of your pocket if your child is speaking to them and they're raising concerns. Additionally, these people that the children might be speaking to, therapists, counselors, teachers, they're mandated reporters. If something really is bad, they're going to reach out to CPS. And I know everyone gets afraid when they hear CPS, that's going to be an investigation. It could affect, whether or not the children are going to be living with you. But, if there's nothing going on your side and it's really concerns with the other parent, a CPS investigation, having the state step in, really come and make an investigation about this, make recommendations of who the children should be with, is going to be a great resource that can be utilized in these cases.
Thank you so much, Will. And thank you to all of our panelists today. We are right at the end of our time. And I wanted to also thank everyone who registered and attended today. Please do call the firm if you need any help with questions about custody or other family law issues, whether it relates to mental health or substance use. Speaking with a licensed attorney to talk through what your options and rights are is important to protect the welfare of your children. Be on the lookout for future webinars in 2024 and 2025 on our second and fourth Wednesday of every month. Don't forget to go to denverdivorceattorneys.com and get a free consultation today. Thank you.
I hope you enjoyed this episode of our webinar series. You can reach us at denverdivorceattorneys.com. You can call us at 303-799-8155. We're on Instagram, Facebook, Twitter, TikTok, LinkedIn. You can find us if you need us, and we're here to help. Thank you, and see you next time.